Good afternoon. My name is Mark Watkins, and over the past few weeks, I've been doing a series of videos in relation to some high profile cases involving the death or murder, as I call it, of certain individuals in our society, namely black individuals who were killed by either law enforcement or someone thinking that they were law enforcement who killed a black person and they were not immediately held accountable or have not been held accountable. Um, the purpose of this video is to discuss the murder on Monday, Memorial Day 2020, of George Floyd. Mr. Floyd was being detained by law enforcement in Minneapolis, Minnesota, for allegedly passing a forged or fake $20 bill. During the course of his apprehension, an individual by the name of Derek Chauvin or Chauvin or however you pronounce it, who was up until Monday a member of the Minneapolis Police Department, was seen on video in public in front of witnesses with his knee in the neck of Mr. Floyd. Mr. Floyd was face down, already handcuffed, in custody, so there was no reason for the officer to do what he did in putting his knee in the neck of Mr. Floyd. I saw a news report or an article this week of the chief of police of the Miami Police Department, and he said what I knew is that no law enforcement agency in the country is taught to handle suspects in that manner. If you're going to use force on an individual, it's to protect yourself or to apprehend someone who is being combative. By all indications, by all information that is presented, Mr. Floyd, prior to his death, was not being combative with the officers and was already in handcuffs. That means his hands were detained behind him. He was not moving, he was not going anywhere. Mr. Officer Chauvin, or Chauvin, however you pronounce his name, had his knee in the neck of Mr. Floyd for approximately 9 minutes. Mr. Floyd could be heard by witnesses saying that he can't breathe, but the officer at no point in time removed his knee from the neck of this individual who was already detained for a period of 9 minutes. As you've probably seen in the news, Minnesota has pretty much exploded with protests across the city. The reason being is even though the officer was fired the very next day, no charges came from the local district attorney's office, and I believe it's called Hennepin County, Minnesota. The DA just yesterday, I believe, or maybe it was earlier today, said that he did not think that he had enough information to put forth a criminal case against the officer or officers in charge. Four officers were involved. There was one individual who had his knee in the neck of Mr. Floyd. There were three other officers who were surrounding Mr. Floyd as he laid prone on the street, dying. The uh, the DA in that jurisdiction, Mike Freeman, said just the other day that he did not think that he has enough information. However, today, as of I'll say 2 o'clock Eastern Time, the former officer has now been charged in the death of Mr. Floyd. The protest that we saw in Minnesota was the fact that A, Mr. Floyd was murdered, B, that the officer responsible, who was known to have caused his death or been at least somewhat responsible for his death, was not immediately charged. Violence or protests erupted in the city wanting action to be taken by those in power. And as I said, as of approximately 2 p.m. Eastern Time, the officer many feel are responsible for the death has been charged with murder in the third degree and manslaughter. Now, I know a lot of people are upset with the charges and how light they seem. And the purpose of this video is to explain certain things. First and foremost, just because an individual is arrested for one charge does not mean that other charges can't be put on them later. For example, you may be arrested for shoplifting and possession of marijuana. But once a prosecutor gets hold to the file, which includes the police reports, sometimes it may include videos, there may be other things that they see. The people who take out the warrants are law enforcement. Law enforcement are the police officers. They are not lawyers. They don't necessarily see what the prosecutors see when they're using their analysis of what the facts are. I did not say this in this particular video, so let me go ahead and back up. If I didn't say my name is Mark Watkins. I'm currently a criminal defense attorney in Atlanta, Georgia. Prior to being a defense attorney, I was a prosecutor. So what I'm telling you is based on the experiences that I've had personally as a prosecutor. And by that I mean when I got a file in the past, and I would read through the police reports and I would look at the warrants and I would see what the individual was charged with based on what my analysis of the police reports were and what I felt I may be able to prove at trial would determine what charges I put on an individual and presented it to a grand jury for the case to be indicted. So going forward to this case, now former Officer Chauvin has been charged with manslaughter and murder in the third degree, but that doesn't mean that whoever's going to be handling this prosecution, I don't know if it's going to be the state attorney general's office or the local district attorney Mike Freeman's office, but whoever handles this case, even though there is a third degree murder charge now at this point, that charge can go up or down depending on the analysis of the prosecutor handling the case. Now, based on the law in Minnesota, let me tell you what the different degrees of murder are. Forgive me, I have to put on my glasses. Okay, there is murder in the first degree, which is Minnesota Statute 609.185. And it says, whoever does any of the following is guilty of murder in the first degree and shall be sentenced to imprisonment for life. 1. Causes the death of a human being with premeditation and with intent to effect the death of the person of another. Subsection 2. Causes the death of a human during sexual conduct. That's not it. 3. Causes the death of a human being with the effect of the death of the person of another while committing or attempting to commit burglary, aggravated robbery, kidnapping, arson, and a bunch of other felonies that do not include just a regular assault. So that's not it. Subsection 4. Causes the death of a peace officer. That's definitely not it. Subsection 5. Causes the death of a minor. That's not it. Subsection 6 causes the death of a human being during domestic violence. That's not applicable. Subsection 7 causes the death of a human being while conspiring to commit, or attempting to commit a felony crime to further terrorism, and the death occurs. And I would argue that that's not it. The only subsection of first degree murder that might be applicable is subsection 1. That's 609.185A1, which is causes the death of a human being with premeditation and with intent to effect the death of the person or of another. So let's look at second degree murder in Minnesota. Second degree murder in Minnesota is Minnesota Statute 609.19. Whoever does either of the following is guilty of murder in the second degree and may be sentenced to imprisonment for not more than 40 years. Subsection 1 causes the death of a human being with intent to effect the death of that person or another, but without premeditation. Excuse me. Subsection 2 causes the death of a human being while committing or attempting to commit a drive-by. That's not applicable. Let's see. Subsection 2 of unintentional murders. Whoever does either of the following is guilty of unintentional murder in the second degree and may be sentenced to imprisonment for not more than 40 years. Subsection 1 causes the death of a human being without intent to effect the death of any person while committing or attempting to commit felony offense other than criminal sexual conduct, or second degree with force or violence or drive-by shooting. That's possible. Subsection 2 causes the death of a human being without intent to effect the death of any person while intentionally inflicting or attempting to inflict bodily harm upon the victim when the perpetrator is restrained under an order for protection and the victim is a person designated to receive protection. So basically, that's if somebody has a TPO or a restraining order against somebody and you commit an act that causes that person's death, you would be guilty of second degree murder under subsection 2. However, going back up to subsection 1 under unintentional murders, I'll read it again. Causes the death of a human being without intent to effect the death of any person while committing or attempting to commit a felony offense other than criminal sexual conduct in the first or second degree with force or violence. So let's break that down. Causes the death of a human being. Well, obviously, Mr. Floyd was. Without intent to affect the death of any person. Now, I can't say that the officer knew or intended to cause the death of Mr. Floyd, even though he heard Mr. Floyd say that he can't breathe. Okay? The remainder of that sentence. While committing or attempting to commit a felony offense other than criminal sexual conduct. The issue is going to be, the analysis is whether or not the officers or now former officers' actions could be considered as a felony by using his knee in the throat excuse me, of Mr. Floyd as he laid prone on the ground while he was under arrest. Okay? But what Chauvin is actually charged with is murder in the third degree, which is Minnesota Statute 609.195. It reads, whoever without intent to effect the death of any person causes the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life is guilty of murder in the third degree and may be sentenced to imprisonment for not more than 25 years. That's subsection A. Subsection B, excuse me, it reads, whoever without intent to cause death proximately causes the death of a human being by directly or indirectly unlawfully selling, giving away, bartering, delivering controlled substance. Okay, subsection B of third degree murder involves drugs. So if your drug dealer gives you some bad drugs and you die, you're guilty of murder in the third degree under Minnesota law. Going back to subsection A under third degree murder, this is right on point. Okay, I'll read it again. It reads, whoever without intent to effect the death of any person causes the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life is guilty of a murder in the third degree. The punishment is up to 25 years in prison. I think it goes, or there's no doubt whatsoever that what the now former officer did showed a depraved mind. It showed that he had no regard for the life, health, and well-being of Mr. Floyd, as he said numerous times that he cannot breathe. I have not read what the manslaughter charges are up there, but if you can bear with me, I can look that up and see what it reads for Minnesota. Now, I'm not aware of any other charges for this particular situation. And let's see what the Minnesota statute says. There are several degrees of manslaughter in Minnesota. Manslaughter in the first degree, which is 609.20, and it reads, whoever does any of the following is guilty of manslaughter in the first degree and may be sentenced to imprisonment for not more than 15 years and to pay a fine of not more than $30,000 or both. The elements of that crime are intentionally causing the death of another person in the heat of passion, provoked by such words or acts of another as would provoke a person of ordinary self-control under like circumstances. So that's an example of that would be if I'm walking down the street and somebody calls me a nigger, as an example, and I pull out a gun and shoot them, that very well could be considered manslaughter, and I could be punished for up to 15 years or pay a fine of not more than $30,000 in Minnesota under manslaughter in the first degree. Subsection 2 of this is violates subsection 609.224 and causes the death of another or causes the death of another in committing or attempting to commit a misdemeanor or gross misdemeanor offense with such force and violence that death of or great bodily harm to any person was reasonably foreseeable, and murder in the first or second degree was not committed thereby. Okay. Subsection 3. Intentionally causes the death of another person because the actor is coerced by threats made by someone other than the actor. Okay, that doesn't apply. Proximately, subsection 4 is proximately causes the death of another without intent to cause death by directly or indirectly. Okay, that's drugs as well. Subsection 4 involves drugs. Let's see, subsection 5, manslaughter, involves a juvenile, so none of that is applicable. So, under manslaughter in the first degree, it seems that only subsection 1 is applicable, which is intentionally causes the death of another person. Well, actually, no, that's not applicable, I don't think. Because I don't think that Mr. Floyd did anything that would cause anybody to act in such a way, and I don't think that there was any provocation on Mr. Floyd's part that got Mr. or the officer to act in the manner that he did. Let's see if we can find what manslaughter in the second degree is, if I can pull that up. Bear with me. Okay, manslaughter in the second degree, which is Minnesota Statute 609.205. And it reads, a person who causes the death of another by any of the following means is guilty of manslaughter in the second degree and may be sentenced to imprisonment for not more than 10 years or pay a fine of $20,000 or both. Subsection 1. By the person's culpable negligence, whereby the person creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. This is definitely right on point. There is no doubt whatsoever that by putting his knee on the neck of Mr. Floyd, the officer took a risk that was consciously, that could possibly cause a death or great bodily harm to another. So that's definitely appropriate. Subsection 2 is not appropriate. Subsection 3 is not appropriate. And subsection 4 is not appropriate, and neither is 5. So I would say, excuse me, I would say that the now former officer, based on the evidence that we have, could very well be prosecuted for manslaughter under Minnesota Statute 609.205, subsection 1. And again, that is the person's culpable negligence, whereby the person creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. Based on the evidence that we have, or based on the information that we've seen, based on the video, I think that that's appropriate. The problem that I know that people are going to have is that charge only carries a maximum term of imprisonment of 10 years. I want to say that that's the amount of time that Amber Geiger received for her actions in Dallas, Texas, about a year or two ago. And let's see what we have for manslaughter in the third degree, if there is one. No, it just appears that there is manslaughter in the first and second degree. And so I will reiterate, based on my very brief reading right now of the law, that it appears that that is an applicable crime as well in this particular situation. Now, what people need to understand is, generally speaking, you can charge several different charges on an indictment. In one of my other videos that I explained what an indictment is. And basically, when you believe that a crime has been committed, you read the statute, feel what crime has been committed based on the facts that you have, and then you present that information to a grand jury. If a majority of the grand jury feel that there is enough evidence or probable cause to go forward with the case, then the case is therefore indicted. Okay? After the case is indicted, the next court date, or the first court date after an initial bond hearing, the next court date will be the arraignment. The arraignment is when an individual is officially notified of the charges against them. The reason why that is important is because, as I said initially, you can be arrested for one thing, but once a prosecutor gets the case and gets the charges, they can put something else, charge you with a different crime. So the actual case that you have to defend is contained in the indictment, and you receive the indictment at your arraignment when you plead guilty or not guilty. In this particular situation, they could charge conceivably murder and manslaughter, and he could be tried for both of them, even though the actions were the same actions. Now, if he is convicted of both of those cases, at least down here in Georgia, I can't speak for Minnesota, and I'm going to assume it's the same, but I don't know this for a fact. But what would happen is you wouldn't be sentenced on both murder and manslaughter. What would happen is one charge would merge into the other charge. And by that I mean the lesser, it's called a lesser included to a certain degree. Okay, that's what it is. The actions that would affect the smaller case, the case that doesn't have as much time incarceration, would merge into the other case, into the other charge, I'm sorry, and that would be the controlling sentencing guidelines for the judge. So the person wouldn't be looking at, unless there was a separate act, but if the acts or the activity of the defendant are the same, the one charge would merge into the other, and the individual will be sentenced to the highest maximum, possibly the highest maximum on the one that carries the most time incarceration. So in the situation that we're looking at third degree murder and manslaughter. Because the manslaughter charge only carries 10 years in prison, what would happen is the manslaughter would merge into the third degree murder charge, and he would be sentenced to that. It wouldn't be where it would be one after the other in this particular situation. It wouldn't be He wouldn't be sentenced consecutively on those two charges. Now, if there are other charges that this officer has to face, like say for example, violating oath of office, if there was any reports that he filled out and he lied about it, those are separate. That's something separate and distinct. So if he has those charges as well, they could conceivably run consecutively to the other counts. So right now, we don't know what the DA or whoever's handling this prosecution is going to actually present to a grand jury. People need to just relax for right now and understand that this is going to be a long process. I don't know who's going to be handling the prosecution. I don't know what charges the now former officer is going to have to face. But understand, just because he was initially charged with third degree murder does not mean that he won't face more severe charges once whoever's handling the prosecution takes a look at it. Okay, so hopefully this was somewhat helpful. Hopefully you can understand everything that I'm saying. If you have any questions, feel free to post your questions in the comment section below. Thank you.